Now to New Hampshire, where we are listening to testimony in the Adam Montgomery murder trial. This father is accused of beating his 5-year-old daughter to death and then hiding the body in various locations for a period of months. Right now, the jury is hearing from a latent print examiner, direct examination by the state. Let's go back in.
You reviewed prior to testifying today. Nothing to do with this case, is that correct?
No, as far as I know, they're just stock images of fingerprints or friction-ridged skin.
So, Mr. Rolowitz, what is a fingerprint?
A fingerprint or friction-ridged skin is the skin that's on the grasping surfaces of your palms and your fingers, as well as on the bottoms of your feet and your toes. Its name implies its function. Friction-ridged skin provides friction to those surfaces of your hands and your feet in order for you to be able to better grab things.
And what are some of the basic fundamentals in fingerprint, in the science of fingerprint and palm print analysis, identification and analysis?
So, two of the basic fundamentals in fingerprint analysis and comparison are that the friction-ridged skin that you are born with is unique to you. So any individual has unique patterns and flows of friction-ridged skin across their hand. And then the other fundamental is persistency of that detail. So the details that are present in your friction-ridged skin should persist throughout your life, barring any catastrophic change.
And the images that are depicted on the screen there, what do they depict?
These two images, the image on the left shows a fingerprint, specifically the distal phalange of a finger, the one furthest from the palm. It's showing the friction-ridged skin present on that. And then the photo on the right is showing a palm print, or a portion of the palm print. This portion of the palm is called the interdigital palm. It's just underneath where the fingers meet the palm, and it's showing the friction-ridged skin there.
Can you tell the jurors what a latent impression is?
Latent impressions are, rather than your physical skin, your friction-ridged skin, a latent impression is a chance impression that might be left behind when an individual touches an object. So the residue that is present on your skin may deposit itself onto a surface, leaving a copy, essentially, of your friction-ridged skin on that surface. It can also be the inverse, where if a surface is dirty, your friction-ridged skin could lift up the contaminant that's on that surface, leaving almost a negative image of your friction-ridged skin behind.
Can you tell the jurors what a known impression or known print is?
Known impressions they're also referred to as exemplar impressions or record impressions. So these impressions are taken anytime someone is fingerprinted. These are a known recording of an individual's friction-ridged skin. Traditionally, these were done with ink, by rubbing ink onto someone's finger and then rolling that finger on a piece of paper to record that. Now there's digital systems that capture the same information.
And how are fingerprints deposited onto an item?
So again, latent prints, it's a chance recording. So there's a possibility of when someone touches something that friction-ridged detail can be left behind. If some of the residue that's on your hand stays on the surface, or if residue that's on the surface comes away on your hand.
So is it like what you'd see on TV, where if someone touches something, it always leaves a fingerprint?
Not always. There's a variety of factors that may inhibit deposition of friction-ridged detail. The easiest one that I can think of is if someone was wearing gloves. When I work in the laboratory, I wear gloves so that I don't leave fingerprints on the things that I'm working on. That's the easiest way to inhibit deposition.
What determines, other than the gloves, what determines whether fingerprints are left on an object?
There's other types of surfaces that are very difficult for fingerprints to be left behind on. So for instance, clothes, these types of porous surfaces, they don't hold friction-ridged detail or fingerprints very well. Surfaces that do hold fingerprints very well are nice, smooth, non-porous surfaces, or things like pieces of paper, the adhesive side of tape. Those things hold fingerprints very well. It also depends on environmental factors. So if the surface is very wet, the likelihood that a fingerprint may remain goes down. If a fingerprint may also be deposited, but then later be washed away if it's raining. So there's a variety of factors that go into deposition.
And how long do fingerprints generally remain on an object?
It's difficult to say exactly how long a fingerprint may stay on an object. Again, it depends on environmental conditions. So to give an example, if a fingerprint is left on an exterior window in the baking sun, and then it rains the next day, and then we go through some New Hampshire weather and it snows or we have a nor'easter, there's a higher chance that that fingerprint is going to be washed away or wiped away than, say, a fingerprint that is inside a house on a metal fridge that gets touched, every day. Likely there will be fingerprints there much longer.
I want to switch gears just a bit. Once you've received a fingerprint, how do you go about analyzing it?
When I'm looking at fingerprints, I'm trying to analyze any of the information that's present within them. So the information that I'm looking at is a macroscopic to a microscopic feature. Generally, we describe these as level 1, 2, and 3 detail.
Mr. Orlowitz, how is an identification made and a comparison conducted?
A comparison is conducted by taking the analyzed latent impression and then comparing it to known impressions or a record impression to determine if there's the same source or if they're not the same source. An identification specifically is a conclusion that can be rendered if it's my determination that the latent print and the record impression have enough detail in similarity in order for me to say that they came from the same source.
And so the screen shows this methodology ACE. Can you describe that to the jurors?
This is the analysis, comparison, and evaluation methodology that I use on every case that I work. This is the methodology that most latent print examiners in the field use. So analysis is, again, assessing the detail. So assessing those macroscopic and microscopic features, those 3 levels of detail. Once that's done, I would move to the comparison phase, comparing the latent impression that I analyzed to known record impressions. And then my evaluation is my final conclusion of my comparison phase. So whether I identify the print, which is, as I said, when it's my opinion that the 2 impressions came from the same source, or if I exclude the print, meaning that the latent impression and the record impression, I believe, are from different sources, there's a third conclusion I can come to called inconclusive. This conclusion is used if the record impressions that I have available to me are too low quality in order for me to definitively say whether the latent print came from them or did not come from them.
Mr. Orlowitz, can you walk us through that identification process and the different levels of detail that you're looking for to make a comparison?
So during my analysis, again, assessing the details present in the latent print, I like to think of it as starting with a macroscopic view of the impression and then moving to a microscopic view. There's 3 levels of detail. The first level of detail is ridge flow. So how the ridges themselves are flowing across the finger or across the hand. In fingerprints specifically, there are 3 pattern types that are typical to see. There is an arch pattern type, a loop pattern type, and a whorl pattern type. Those are helpful in determining anatomical source and orientation. If I can see a pattern type, I can determine this likely came from a distal phalange portion of the finger, and I can usually determine which orientation is up on that, which direction would be up on that latent impression. Because all I'm assessing with level 1 is the ridge flow, I would not make an identification just based off of that ridge flow. Lots of people in the population share pattern types. So a lot of people have whorls, a lot of people have loops, a lot of people have arches. That's a macroscopic detail. But the microscopic detail, the level 2 and 3, is where I can begin to make an identification.
So let's discuss level 2 detail.
The level 2 detail is ridge path formation or deviation. So this is moving from looking at the entire latent print to looking at one single ridge at a time. And what I'm determining and looking at in my analysis is where these ridges are ending, where they're splitting, where there's smaller ridges. So I'm searching for attributes specific to each ridge. A grouping of these attributes can be used to identify a latent print to a source.
And so I see bifurcations up there. Can you describe what that is for the jurors?
Bifurcation would be where a ridge splits from one ridge into two ridges. A ridge ending is exactly what it sounds like. It's where a ridge ends. And then a dot or a short ridge is just a very small segment of ridge instead of a longer portion.
And can you just identification process in terms of level 2 detail? What are we looking at on this slide?
And breaking news out of Ohio. The jury has a question in the trial against Jason Mead. The jury has now been deliberating for about 2 hours, and just a few minutes ago, according to our Court TV crew, the jury just asked for several exhibits, including a copy of Mead's statement, several witness reports, as well as a list of exhibits. So that's the jury question, requesting that information so that they can receive it. Let me bring in now trial attorney Michael Jaafar to ask you, thank you for joining us first of all. Let me ask you about what you think this might mean. Just a reminder for those joining us, this was a U.S. Marshal. He's accused of murdering a 23-year-old Casey Goodson. As Casey Goodson was entering his grandmother's house, testimony indicated he had a bag of sandwiches and keys when he was entering the house. What do these questions mean to you, if anything?
Judge Esche, can you repeat the questions because it cut off a little bit? I didn't hear what his questions were.
Yes, he wanted to know, the jury wanted some of the exhibits. Number one, a list of the exhibits. Number two, part of his statement. And then some of the other exhibits that have been admitted into evidence. You know, to me, that means, Michael, that obviously I believe juries look very closely at all of the evidence, but it means there's some detail that some of the jurors are disagreeing about, and they really want to take a deep dive to sort out if they believe him or not.
I've looked at this case. You know what that sounds to me? It sounds to me like doubt. Obviously, they went in, your job as a defense attorney is to make sure the jury goes into the box with doubt. It seems to me that I agree with you. Doubt crept in, and so they want to have a better understanding of the exhibits and of the evidence. And on one side, they're looking at a marshal, and another side, they're looking at a victim. And so it looks to me like I'm happy to hear juries ask these questions, to be honest with you, Judge Esche, because it seems that they would be analyzing the stuff and looking at what matters, and they did not go into the box having made a decision based on their passion or emotion. So it does look to me like there's doubt, and they're debating the evidence, and they want to have a more granular look at the evidence. So yeah, I agree.
And one of the things, and I don't know if I mentioned it specifically, was a copy of Mead's statement that they wanted to see as well. So talk a little bit, because a lot of viewers, when they join us, say, wait a minute, why did they have to ask for that? Doesn't it go back in the jury room? Well, you and I both know that every state's a little bit different. Sometimes it can even depend on the judge hearing the case, but they don't always go back with all of the information. They have to rely on what they recall on their memory. So, you know, what is the practice you're accustomed to, that they have to ask for specific things or that they get everything?
So in Ohio, in the practice I'm accustomed to is these jury instructions are like horse trading between the litigants, the defense attorneys, and the prosecutors. And the jury instructions, what the court system tries to do in Ohio is try to kind of control what the jury sees in an attempt to kind of limit the amount of distractions, even though evidence is not technically a distraction. So from what I'm accustomed to is the jury's going, if you give them all the evidence, a jury can't make a decision, because then you're asking them to look at all the evidence that the prosecutors thought mattered and the defense attorneys mattered, Whereas opposed to if you just give them jury instructions and say, listen to the evidence as it's proposed and listen to the closing arguments, which is the attorneys arguing the case after the evidence has been admitted, that's what juries go into. They don't go in there with the statements. To my recollection, I don't recall a jury going into the box with statements of the defendants, of any of the participants or the witnesses, unless they ask for it. So to me, that doesn't sound off that they did not go in with that, even though that's a very material point of evidence. And the judge could have just said, well, you heard it be admitted into evidence along with a million other things, but hey, I guess this matters to you. You want to granularly debate it. It also sounds to me like at least one juror is debating with another juror as to what that statement said. And they said, you know what, let's look at the statement and see which one of us is right. I've seen that happen.
And I agree with you. And remember, he testified. So, of course, they have a written statement they can look at, and they can weigh that against his testimony in court. And I appreciate you pointed out, that it is different in different places, but then in Ohio, and I don't disagree with it, because jurors are always told you are going to have to rely on your memory, what you heard, and then you have to debate that during deliberations if you disagree. So I think it's sound practice. Of course, if we have any more updates, we're going to bring them to you. You're going to stay with me, Michael. When we come back from this break, more testimony in the Adam Montgomery trial, including where fingerprints were found. Stay tuned. Welcome back to Court TV Live. Thank you so much for joining us this afternoon, where we are in New Hampshire covering the trial in the brutal death of little Harmony Montgomery. Prosecutors say that the 5-year-old went from this little girl full of life to being scared, bruised, and eventually killed at the hands of her own father. Adam Montgomery stands accused of beating her to death, but he continues to choose not to face a jury who may or may not find him guilty of second-degree murder. Let's get you back into the courtroom now as the jury hears from a latent print examiner. He's facing direct examination by the state, and we're going to take you right back in where we left off.
This photo is showing specifically those 3 features that I just mentioned: bifurcations, ridge endings, and dots. It's pointing them out in the greater ridge flow in the larger image, and then zooming in to show you the exact feature in the smaller images.
Let's discuss level 3 detail.
Level 3 detail, this is the most microscopic level of detail that I use during my comparisons. This level of detail goes from looking at a single ridge to looking at the exact characteristics and attributes of that one ridge. So where the pores are present on top of the ridges, what the edges, the edge shape of the ridges look like. This level of detail is not commonly recorded in latent impressions or record impressions because it is so microscopic. But when it is present, it is highly discriminating and highly useful in identification and exclusion decisions.
Can an identification be made in all cases?
No.
And what does it mean if you cannot find a fingerprint during your analysis?
Do you mean if I don't develop any on evidence, or?
Correct, yes.
So if no fingerprints are developed on evidence that I'm processing, I can't say whether or not that item was touched or had ever been touched. Like I said before, there's a large number of factors that go into deposition of a latent print, as well as if that latent print remains on the surface. And I have no knowledge or control of those factors before the evidence gets to the laboratory.
So if a fingerprint or friction ridge is not observed on one of the items you're analyzing, does it mean that that was not touched?
No.
And I think you touched on this earlier, but speaking generally, what variables may cause a fingerprint not to be detected on one of the items that you're analyzing?
The fingerprints may be wiped away over time if an object contacts another object, or if something is cleaned, as well as environmental factors. So latent print residue is a combination of waters, fats, amino acids. Over time, those things degrade, they evaporate. So there's a potential that the print could itself just disappear.
Mr. Orlowitz, I want to switch gears and discuss State v. Adam Montgomery. Did you conduct analysis in this matter?
Yes.
And what did you process?
I processed 5 items of evidence that were submitted to the laboratory for latent print impressions.
And I want to begin with an item with the evidence number JD47. Does that item stand out to you?
Yes.
What was that item, or what is that item?
I remember that item being a red Igloo brand cooler.
Do you think you'd recognize that if you saw it today?
Yes.
Your Honor, may I approach?
Yes, you may.
So, Mr. Orlowitz, I'm showing you what's been marked for identification as State's Exhibit 29. Do you recognize that item?
Yes, I do.
And what's depicted in this image?
This is JD47, the red Igloo brand cooler that I processed at the laboratory.
Is that a true and correct copy of the item that day?
Yes, it appears so.
Your Honor, the state moves to strike State's Exhibit 29 for identification.
No objection.
All right, the idea is stricken. It's entered as a full exhibit. It may be published.
And so, if you can just point to, let's talk about this. Did the item arrive in your laboratory that way, appearing as it does in this image?
To my recollection, yes, it did.
And are there stickers placed on this item?
There are, yes, several.
And had this item, at the point that this image was taken, had it undergone analysis?
I don't recall if it had gone through my laboratory analysis at this point. I believe, I don't want to speculate on that. I don't recall if that was before analysis, but I believe it might have been.
If I could have just a moment, Your Honor.
Yes.
This is crucial testimony. It's that red cooler. Remember, there's been testimony all over that that red cooler is where the body of Harmony was put by Adam Montgomery. Stay with us. We're going to hear more about fingerprints. Whose fingerprints were found on that cooler? That's coming up next. And we are bringing you the murder of Harmony Montgomery trial taking place in New Hampshire. Defendant Adam Montgomery is charged with second-degree murder in the death of his 5-year-old daughter, Harmony. She was last seen in 2019, but her body has never been found. And now a latent print examiner's on the stand. We want to take you back in for more of his direct testimony. He's just said that he was asked to examine 5 different items that were provided to the lab. The first one he's now talking about, that red cooler in which Harmony was put by Adam Montgomery based on testimony from this trial. Let's go back into court.
Mr. Orlowitz, I'm showing you what's been admitted as State's Exhibit 28.
Okay.
Having seen this item, does that refresh your recollection on whether or not image State's Exhibit 29 had undergone analysis?
Again, I don't believe it went through latent print analysis before that image was taken.
Okay. At some point, did it?
Yes, it did.
And you conducted that analysis?
Yes.
And again, you identified it in the photograph there. Would you recognize that item if you saw it today?
Yes.
Mr. Erlowitz, I'm showing you what's been marked for identification as State's Exhibit 73, and I'm just going to ask that you stand. Do you recognize this item?
Yes, I do.
Is this the item that you conducted testing on?
Yes, it is.
You removed it from the baggage. The igloo cooler that you mentioned examining, is this that item?
Yes, it is.
How do you know that it's that item?
I recognize the item from when I processed it. I also believe if it's the same packaging or the packaging is present inside from when I analyzed it at the laboratory, my initials should be on a evidence tape seal. It looks like it may have been repackaged since I processed it. But
So this is a true and correct. This is the item that you.
yes, it is.
Your Honor, I move to strike ID of State's Exhibit 73 and mark as full.
Any objection?
Objection.
The ID is stricken, it's marked as a full exhibit.
May I publish?
Yes, you may.
Mr. Erlowitz, you mentioned processing that item, analyzing it. What were the results of that analysis?
I did not find any friction ridge detail on that exhibit.
No friction ridge detail.
That's correct.
Your Honor, may I approach?
Yes.
Oh, this is new. Then you're on that thing? You're on the slide. Yes.
All right, still with us, Michael Jaafar. We can just talk over this, Michael. They had that sidebar to get that marked. You know, this is standard testimony when they're identifying fingerprints found on objects, yes?
Oh, absolutely. The way this expert obviously knows what he's talking about, and I was riveted by this testimony because it gave me a refresh on how latent prints and palm print analysis works. But this obviously is, in my opinion, the biggest expert witness in a case like this because we really want to see what fingerprints we saw in that cooler, and it's kind of a grotesque subject matter that a man's daughter was put in a cooler, and once they establish that, I don't see any way out of this for the defendant.
Yeah, I don't disagree with you, and I agree. It was a really great summary. The 3 levels of detail that he looks at, the ridge floor, the level 2 detail, or ridge flow rather. He was really, I thought, very simple in describing how he does the analysis. Now, he's looking at these exhibits now, and let's see, Michael, if they resume answering quickly. If not, I'm going to pull you back in. Michael, one more thing, and we'll stop talking when he starts talking. That red cooler you just mentioned, I mean, look, that photograph's right up there. The jury is seeing that this entire time, thinking about he might have put Harmony in it. I think they're talking now. Back to court.
Yes, I do.
And how do you recommend?
These are images that I took or generated in relation to my latent print processing and analysis and comparison for this case.
Are those true and correct photographs of the images or the items that are depicted?
Yes, they are.
Your Honor, the state moves to publish. So strike ID for state's exhibit. What's marked for identification is items 109 through 135.
No objection.
Right, the ID is stricken, they're entered as a full exhibit.
So, Mr. Orlowitz, switching now to the white metal ceiling. It's MER 3A and 3D. So metal ceiling, a vent, and a section of drywall. Did you have an opportunity to analyze those items?
Yes, I did.
And based on your analysis, were you able to develop friction ridge details for those items?
I was able to document friction ridge detail on MER 3D, which was
And
section.
thank you to Michael Jaafar for joining us this hour. Before we head to break, there's a big hearing tomorrow in Fulton County, Georgia, that could have an impact on President Trump's election interference case. Attorneys for Trump and his 18 co-defendants want the Fulton County District Attorney, Fani Willis, and the lead prosecutor, Nathan Wade, disqualified from the case. Now, Willis, the DA, hired Wade to oversee the case, but has admitted they are romantically involved. Defense attorneys allege that Willis has benefited financially because of her relationship with Wade. Here are my thoughts from the bench on this. Judges have an obligation to ensure that they do not only not have a conflict and no ethical considerations, but that they take it one step further and make certain there's no appearance of impropriety. This responsibility is also true of a prosecutor who's elected to represent the state. Given the admission to the romantic relationship